Florida's traffic enforcement changed in 2023 with Senate Bill 1718, and the financial consequences are hitting drivers hard right now. If you get pulled over and cannot show proper identification or a valid driver license, you face criminal charges, fines up to $500, vehicle impoundment fees exceeding $1,000, and potential immigration enforcement. These penalties connect directly to your ability to work, pay rent, and keep housing in Florida. This affects employed residents, families with children, and anyone who drives daily. Understanding these laws protects your wallet, your job, and your home. Here's what Florida law actually says. Number 1, Florida statutes. Chapter 322 requires valid driver licenses for all drivers. Florida statutes section 322.03 establishes that every person who operates a motor vehicle on Florida's public roads must possess a valid driver license. This requirement applies to all drivers without exception. The statute does not differentiate between residents and visitors, between commuters and recreational drivers, or between people with different immigration statuses. When you apply for a Florida driver license under Section 322.08, you must provide specific documentation. The state requires proof of identity, proof of Social Security number, and 2 documents proving residential address. Most critically, you must provide proof of lawful presence in the United States. Acceptable documents include a valid U.S. passport, a birth certificate issued by a U.S. state, a certificate of naturalization, or immigration documents showing lawful status, such as a permanent resident card or employment authorization document. Some states take a different approach. Connecticut, Delaware, Hawaii, Illinois, Maryland, Nevada, New Mexico, Utah, Vermont, Washington, and several other states issue driver licenses or driving privilege cards to residents without requiring proof of lawful presence under federal immigration law. Senate Bill 1718 changed how Florida treats these out-of-state licenses. Section 7 of that law specifically addresses out-of-state driver licenses and identification cards. The statute declares that any driver license or identification card issued by another state to an individual who did not demonstrate lawful presence in the United States is invalid for any identification or official purpose in Florida. The practical effect is straightforward. If you hold a driving privilege card from Illinois, you cannot legally drive in Florida even though your Illinois license is completely legitimate in Illinois. The license itself is real, properly issued, and legal in its home state, but Florida law treats it as if it does not exist. Number 2, criminal penalties under Florida statutes. Section 322.39 for operating without valid license. Once Florida law establishes that you lack a valid driver license, criminal penalties apply through Florida statute section 322.39. For a first offense of driving without a valid license, Florida law classifies the violation as a second-degree misdemeanor. Under Florida's criminal code structure found in Chapter 775, a second-degree misdemeanor carries a maximum penalty of 60 days in county jail and a maximum fine of $500. Most first-time offenders do not receive the maximum 60-day jail sentence. Judges typically impose fines, court costs, and sometimes probation. However, the possibility of incarceration exists. If you have other charges pending, if you have a prior criminal record, or if aggravating circumstances exist, a judge can impose jail time even for a first offense. The $500 maximum fine is only part of the total financial burden. Florida's court system adds mandatory court costs to every criminal conviction. These court costs vary by county, but typically range from $200 to $400. They fund the court system, public defenders, prosecutors, and various state programs. For second or subsequent offenses, the charge elevates to a first-degree misdemeanor. This classification carries up to 1 year in county jail and a fine of up to $1,000. The sentencing guidelines for repeat offenders are significantly harsher. Beyond the immediate criminal case, a conviction creates a permanent criminal record. This misdemeanor conviction appears on background checks conducted by employers, landlords, licensing boards, and others. Many employers ask about criminal history on job applications. Landlords conducting tenant screenings see criminal convictions. Number 3, vehicle impoundment costs that quickly reach $1,000 or more. When a Florida law enforcement officer stops you and determines you are driving without a valid license, the officer has authority to impound your vehicle. Florida statutes section 316.193 and related provisions authorize vehicle impoundment in situations where allowing the vehicle to remain creates safety concerns or when no licensed driver can take custody of the vehicle. Towing companies contracted with law enforcement agencies charge substantial fees. The initial tow typically costs between $150 and $350, depending on the distance from the traffic stop location to the impound lot. the size of the vehicle, and the specific company's rates. Once your vehicle arrives at the impound lot, daily storage fees begin accumulating immediately. These fees range from $25 to $50 per day, depending on the impound company and location. The fees continue every single day your vehicle remains at the lot. Consider a realistic example. The tow costs $250. You cannot retrieve the vehicle for 10 days because you need time to arrange money, transportation to the impound lot, and someone with a valid license to drive the vehicle away. Storage fees at $35 per day for 10 days equal $350. Your total cost is already $600 before any other fees. Administrative fees apply in most cases. The impound company charges processing fees, gate fees, and administrative costs that range from $50 to $150. To retrieve your vehicle, you must show proof of ownership, current vehicle insurance, and critically, you must have someone with a valid Florida driver license present to drive the vehicle off the impound lot. If you cannot afford the impound fees, your vehicle may be lost permanently. Florida Statute Section 71378 establishes lien procedures for towing and storage companies. If your vehicle remains at the impound lot for 30 days or more and you have not paid the accumulated fees, the company can initiate a lien sale and sell the vehicle at auction. Number 4, how loss of driving privileges destroys employment in Florida. Florida's geography and infrastructure make vehicle ownership nearly essential for most employment. Unlike older American cities built around public transit, Florida developed in the automobile era. Cities spread horizontally with suburban sprawl. Jobs are dispersed across wide metropolitan areas. When you lose the ability to drive legally, employment becomes extremely difficult to maintain. Many jobs explicitly require a valid driver license as a condition of employment. Delivery drivers for companies like UPS, FedEx, Amazon, and food delivery services cannot work without driving. Sales representatives who visit clients cannot perform their duties. Home health aides who travel between patients' homes cannot reach their clients. Construction workers who drive to various job sites cannot get to work. Beyond jobs that directly require driving, most Florida employment requires commuting. If you live in Homestead and work in downtown Miami, that is a 30-mile commute. No regular public transit effectively serves that route. If you live in Claremont and work in Orlando, that is a 25-mile commute through areas with no bus service. Employers have legitimate reasons to require valid driver licenses. Company insurance policies typically exclude coverage for accidents involving drivers without valid licenses. If you drive a company vehicle or your personal vehicle for company business while lacking a valid license, the company faces enormous liability exposure if you cause an accident. The loss of employment creates immediate financial crisis. Without income, you cannot pay rent. Under Florida statute section 83563, when rent is not paid by the due date, landlords can serve a 3-day notice demanding payment or possession. From the date rent is due to the date the sheriff physically removes you from the property can be as short as 4 to 6 weeks. During that time, finding new employment without a vehicle, saving money for a new security deposit, and locating new housing is nearly impossible. The loss of your driver license creates a domino effect that ends in homelessness. Number 5, insurance denial and personal liability for accidents. Florida law requires vehicle owners to maintain minimum insurance coverage. Florida statutes section 316.646 mandates at least $10,000 in personal injury protection coverage and $10,000 in property damage liability coverage. Every insurance policy contains exclusions for unlawful acts. Driving without a valid license is a criminal offense under Florida statute section 322.39. When you drive without a valid license and you are involved in an accident, you are committing a crime at the moment of the accident. This triggers the unlawful acts exclusion in your insurance policy. When an accident occurs, insurance companies investigate. If the investigation reveals that you lacked a valid driver license at the time of the accident, the insurance company sends a denial letter invoking the policy exclusion for unlawful acts. This denial means you have no insurance coverage for the accident. If you injured another driver and they have $75,000 in medical bills, you are personally liable for $75,000. If you damaged another vehicle worth $35,000, you owe $35,000 personally. Most individuals cannot pay these amounts. The injured parties hire attorneys and file lawsuits. Courts enter judgments for the full amount of proven damages. These judgments are valid for 20 years under Florida law and can be renewed before expiration. Interest accrues on the unpaid judgment balance at 4.75% per year. Judgment creditors have multiple collection tools available. They can garnish your wages if you become employed. Under Florida statutes, section 77.0305, creditors can take up to 25% of your disposable earnings through wage garnishment. Bank account levies are also available. Property lines are another tool. Number 6, immigration enforcement connections through state and federal cooperation. Florida law enforcement agencies interact with federal immigration authorities in ways that can affect individuals who come into police contact for any reason, including traffic violations. When a Florida law enforcement officer arrests someone for any crime, including the misdemeanor of driving without a valid license, the arrestee is taken to the county jail for booking. During booking, fingerprints are collected and sent electronically to the Florida Department of Law Enforcement, which maintains the state criminal database. From there, fingerprints are forwarded to the FBI's national database. Immigration and Customs Enforcement monitors these databases through an automated system. If ICE has interest in an individual, the system alerts ICE to that person's arrest and location. ICE can then issue what is called an immigration detainer under 8 CFR, Section 287.7. This detainer is a formal request sent from ICE to the local jail asking the jail to hold the individual for up to 48 hours beyond when they would otherwise be released. If ICE takes custody of someone from a Florida jail, that person is transferred to immigration detention. Florida has several immigration detention facilities, including the Crome Detention Center in Miami-Dade County and the Broward Transitional Center in Pompano Beach. Removal proceedings are governed by 8 U.S.C. Section 1229A. The detained individual receives a notice to appear listing the charges of removability. Immigration court proceedings can take months or years depending on court backlogs and case complexity. During this time, the detained person cannot work, cannot access their home, cannot care for family members, and cannot pay bills. Rent goes unpaid, eviction lawsuits are filed. The chain of events from a traffic stop to family separation runs through multiple legal systems. State criminal law addresses the driving without a license offense. Federal immigration law and procedures control what happens next. Throughout this process, the initial trigger was simply being pulled over for a traffic violation while lacking a valid Florida driver license. Number 7, the 3-day notice requirement before eviction proceedings begin. Florida's landlord-tenant law provides specific protections for tenants while also giving landlords clear procedures for addressing non-payment of rent. Understanding Florida statutes Section 83563 is essential for both tenants and landlords. When rent is due and not paid, the landlord cannot immediately file an eviction lawsuit. Florida law requires the landlord to first serve the tenant with written notice. This notice must specifically demand that the tenant pay the rent or deliver possession of the premises. The notice must state the exact amount of rent owed. The tenant then has 3 full days, excluding weekends and legal holidays, to comply. The notice must be properly served through hand delivery, delivery to a person age 15 or older at the residence, posting on the property, or mailing with additional time allowed. For tenants who lost employment because they cannot drive legally under SB 1718 and Florida Statutes Chapter 322, the 3-day notice arrives when they have no money and no immediate prospects for obtaining money. The 3-day period is simply too short to solve a sudden income crisis. If the tenant cannot pay the full amount within 3 days and does not vacate, the landlord can file an eviction lawsuit. Some tenants believe that showing proof of job loss or other hardship will stop the eviction. Under Florida law, financial hardship is not a defense to non-payment of rent. Number 8, county court eviction procedures and default judgment risks. After serving a 3-day notice and receiving neither payment nor possession, the landlord files an eviction complaint in county court. Florida Statute Section 8359 establishes the specific procedures that control these cases. When the landlord files the complaint, the county court clerk issues a summons. This summons is a court order commanding the tenant to file a written answer or response to the complaint within 5 business days after being served. This 5-day deadline is strictly enforced and extremely important. Once served, the tenant has 5 business days to file a written answer. The answer must respond to each allegation in the complaint. Most tenants do not file answers. Many do not understand the legal requirement to file a written document with the court. When no answer is filed within 5 business days, the landlord requests a default judgment. A default means the tenant automatically loses the case because they failed to respond. The default judgment orders the tenant to vacate immediately and typically includes a money judgment for unpaid rent and court costs. After the judgment is entered, the court clerk issues a writ of possession delivered to the county sheriff's office. The sheriff posts a 24-hour notice at the rental property. After 24 hours, the sheriff returns to execute the writ and physically supervises removal of all people and belongings from the property. The entire process from filing the eviction complaint to physical removal can occur in as little as 3 to 4 weeks if the tenant does not file an answer. For tenants who lost employment due to inability to drive legally, this timeline is devastating. Number 9. Eviction judgments create long-term housing barriers. An eviction judgment in Florida creates permanent public records that affect housing access for years. County court records are public information. When an eviction judgment is entered against a tenant, that judgment appears in the court's online database. Tenant screening companies compile these public records. Companies like CoreLogic, TransUnion, Experian, and numerous others maintain databases of eviction records from courts across the country. They sell access to these databases to landlords who use the information to evaluate rental applications. When you apply to rent a property, the landlord or property management company almost always conducts a tenant screening report. Even a single eviction from years ago appears on the report. Landlords view eviction history as the strongest predictor of future problems. Many landlords have policies that automatically reject any applicant with an eviction in their history, regardless of the circumstances. This creates a severe barrier to obtaining housing. You complete applications and pay application fees that typically range from $30 to $75 per application. The landlord runs the background check. The eviction appears, your application is denied, you receive no refund of the application fee. Some landlords will rent to applicants with eviction history but impose additional requirements. They might require a co-signer, double security deposit, or payment of first month, last month, and security deposit all up front. These additional requirements may be financially impossible for someone who just lost housing through eviction. The judgment remains enforceable for 20 years. During that time, the landlord who obtained the judgment can pursue collection through wage garnishment, bank account levies, or property liens. Number 10, practical steps to protect employment, housing, and legal status. Understanding your legal situation and taking proactive steps can help protect your employment, housing, and immigration status in Florida's current legal environment. If you currently hold an out-of-state driver license issued by a state that does not require proof of lawful presence, understand that Florida law may declare your license invalid under SB 1718, Section 7. Your primary option is obtaining a valid Florida driver license, but this requires proof of lawful presence. If you are served with a 3-day notice for non-payment of rent, take it seriously. Read the notice carefully. Verify that the amount stated is correct. If you can pay the full amount within 3 days, do so and get a receipt. If you receive a summons for an eviction lawsuit, you must file a written answer within 5 business days. This is absolutely critical. Failure to file an answer results in default judgment. Even if you do not have an attorney, you can file an answer yourself. Consider contacting legal aid organizations. Florida has several legal aid societies that provide free legal services to low-income individuals facing eviction. The Florida Bar's website at floridabar.org provides a lawyer referral service and links to legal aid organizations. If you have immigration concerns, consult with a licensed immigration attorney. Do not rely on notarios or immigration consultants. Only licensed attorneys can provide legal advice on immigration matters. Document everything. Keep copies of your lease, rent payment receipts, correspondence with landlords, and any documents related to your driver license. If you are a landlord, follow Florida law exactly. Serve proper 3-day notices using the correct format and proper service methods. Do not attempt self-help evictions. Violations of Florida statute section 83.67 result in liability for actual damages, statutory damages up to 3 months' rent, and the tenant's attorney's fees. Both tenants and landlords benefit from understanding that Florida's legal system operates according to specific statutes and procedures. Understanding those rules provides the foundation for protecting your rights and meeting your legal obligations. Florida's driver license laws changed with SB 1718, and these changes affect thousands of residents. Section 7 invalidates certain out-of-state licenses. Chapter 322 imposes criminal penalties for driving without valid licenses. Vehicle impoundment costs exceed $1,000. Employment loss follows license problems. Housing instability results when rent cannot be paid. Chapter 83 controls eviction procedures with strict timelines and serious long-term consequences. If these laws affect you, take action now. Review your driver license status. Understand what Florida requires. If you receive 3-day notices or eviction summons, respond immediately within required time frames. Consult licensed Florida attorneys for driver license, housing, and immigration issues. Document everything related to your housing and employment. Subscribe to this channel for more Florida law analysis. Like this video if you found it helpful. Comment with questions about your specific situation. Understanding Florida law is your first step toward protecting yourself. Share this video with anyone facing these challenges.